Good morning. Today is September the 11th, 2009. My name is James Stratton, and I'd like to welcome you back to my program. I help people through some of the toughest times in their life through a process called mediation. And mediation is all about restoring relationships and reputations in a non-judgmental, non-threatening, and confidential manner that costs less than going to traditional court. Today we're tying up a case that we've been working on all week about an employment law case in which a young lady went to apply for a job at a restaurant and was later terminated. And she filed suit against the business owner on behalf of an assault, sexual harassment case, as well as wrongful termination. Also, the long and short of it is that the defendant, who is the restaurant owner, filed suit against or countersued the plaintiff for defamation. Well, okay, today we get to find out how this all turned out. This actually went to trial right here in Tarrant County, and the judgment was in favor of the plaintiff, which was the young lady who had applied as a waitress at the restaurant. So let's see what the court had to say about it. It's a very long judgment, several pages in length. Let's see what we got here. The court comes back and says the sum of $175,000 represents the amount of award by the jury for compensatory damages in the past. The sum of $30,232.37 represents prejudgment interest. The sum of $1,197.35 represents court cost. Let's see. The plaintiff is entitled to $250,000, representing the amount awarded by the jury for compensatory damages in the past. So that's another $225,000. The plaintiff is ordered to recover $562.50 from the defendant, and $15,000 more if it goes to be appealed. $10,000 if it goes to the Supreme Court. All right, here we go. So that's an awful lot of money, and it just doesn't end. A sum of $65,589.54 is for prejudgment interest on that. An award of the post-judgment interest at 5% per annum. Okay, here we go. What did the jury say? Well, and this was a jury trial, so the charge went before the jury. All right, here we go. Was the plaintiff subjected to harassment based on sex by the defendant? And the answer was yes. The jury came back. Did the defendant discharge the plaintiff from employment due to her sex? And the jury came back as yes. Did the person who perpetrated the assault assault the plaintiff? The answer was yes. Did the person who also owned the company and did the assault employ the defendant? Or the plaintiff. I'm sorry, I got off on that one. The answer was yes. Do you find by clear and convincing evidence that the owner acted with malice toward the plaintiff? And the answer was yes. The question was, how much do you award for mental languages? $250,000. How much do you award for mental anguish in the past? $175,000. Did the plaintiff defame the defendant? And the answer was no. So not a good day for the defendant in court. All right. And I think that pretty much ends it, because they just didn't answer the rest of the questions because it wasn't important to them. Okay? So here we go. That went before a jury. It's a tough day when this happened. This case went before a mediator. It did not mediate, or it did not settle on mediation. This is what we really hate to see as mediators. We hope to settle everything that gets in front of us, but some people just feel like their positions are strong and they're going to take it to the courthouse. That day, the jury awarded their answer, and the people that are involved in this have to live with it. Now, it wasn't a total win for everyone. It may look like the plaintiff got a lot of money in this, but the job is now to collect it. And this case right now is sitting in appeals court. It was perfected on appeal, and now it's going up. And the defendant is hoping on some technicality the appellate court will overturn it or send it back to court. What does that mean? It took 3 years to get to this point on this judgment. And to this day, this woman has not received a dime. Now, is it possible the jury award may be lowered? Yep. But I'll guarantee you the attorney's fees won't be lowered. So if you're a company looking at this situation, the answer is, can you afford to take the chance to be hit with a judgment like that? If you can, go for it. I mean, literally, go for it. If you're a plaintiff, obviously she won this case, so it's a winner. But it's a loser on everything around it. This company now, and we have to remember, the plaintiff was going to this company to be righted for the wrongs perpetrated on her. But now that company, because their reputation has been ruined, has gone out of business, and she may never ever collect this money at all. The second side, or second attribute to this case is this woman has now sued an employer, and her reputation is soiled as well. Because if she goes to apply for a job and they ever find out that she has sued an employer, chances are her chances of employment aren't that good as well. Always keep this in mind. Go to mediation as soon as possible, even before you file for the lawsuit, because now it's not a public event. This is a public event that has ruined some lives. All right, today is September the 11th. I hope you will join me today in remembering those people who perished on 9/11. Also, to honor the people who came to their rescue, the firemen and police departments, and also the military who serve us in this manner. Remember those that have died on our behalf. Have a great weekend. I look forward to seeing you back here on Monday.